Welcome to another legal update from Legaleye, the law firm. I am Debolina Pannu. The High Court of Kerala recently ruled that all unmarried daughters, regardless of religion, are entitled to reasonable marriage expenses from their fathers. The division bench of Justice Anil K, Narendran and Justice PG Ajith Kumar ruled that this right could not be overshadowed by religion. The bench held that the right of an unmarried daughter to get reasonable expenses concerning her marriage from her father cannot have a religious shade. It is a right of every unmarried daughter irrespective of her religion. There cannot be a discriminatory exclusion from claiming such a right based on one's religion. The judgment was handed down on two applications filed by two unmarried daughters of the respondent father. The petitioner daughters had filed a petition with the family court for the realization of Rs 45.92 lakh towards the cost of their marriage, and an order to claim the same amount against the estranged father's property. They also sought an injunction barring the father from selling the property. This was said to have been obtained through financial support from their mother and her family. The family court ruled that the petitioners were entitled to claim only the minimum costs necessary for the marriage and that an attachment of Rs 7.5 lakh was sufficient to protect their interests. Her father, on the other hand, claimed that the land and the buildings on it were wholly owned by him and he was not liable to pay his daughters. He further claimed that his daughter and her mother were Pentecostal Christians and that the community did not believe in the use of ornaments, therefore expenses for his daughters wearing the gold jewelry normally required for marriage did not arise, so he did not have to pay. In Ismail v. Fatima, another Kerala High Court also considered the question whether Muslim fathers are obliged to bear the costs of their daughter's marriage. A division bench of the court held that every father irrespective of religion has such an obligation. The court subsequently ruled that under Section 39 of the Transfer of Property Act, if a person has the right to receive maintenance or a provision for advancement or marriage from the profits of immovable property, that claim can be enforced against the immovable property of the person obliged. Accordingly, the court determined that the petitioner daughters were entitled to seek a claim on their father's property. However, the court ruled that once the property was attached, there was no reason to seek equitable injunctive relief as to the amount required to cover the costs. The court, after examining the petition and materials on file, held that the attachment guaranteeing the amount of Rs 15 lakh was sufficient to protect the interest of the petitioners.
Stay tuned and subscribe to our channel for more legal updates.